And I today wanted to send out a little clip to you all to tell you about a dramatic change in the laws under divorce in Maryland. Maryland is becoming what we call a no-fault state divorce. Um, there's many states in the United States that have no-fault divorce, and Maryland is going that way. Maryland the legislature in Maryland feels strong on streamlining the grounds for divorce and eliminating all fault grounds that we have presently. Presently, we can file a divorce on fault like desertion, cruelty, adultery. The court system now says we don't need to go through those fault grounds, and they've laid out the roadmap to say what are the grounds we can file now. The roadmap that they've set for us is they're saying you can file after October 1st of this year three grounds basically for divorce. One is the grounds of what we call irreconcilable differences. The second ground is 6 months separation. And the third ground is what we call mutual consent, which is one of the grounds that we still have today. Mutual consent does not require a physical separation of the parties. To get a divorce on a mutual consent, as current law states, is that you need to sign a separation agreement, which resolves all the issues between the husband and wife, including marital property, alimony, and if you have children, child custody and child support issues. Now, that ground is still going to continue after October 1st, but the other two grounds that they have going forward is one is what we call the irreconcilable differences, which I mentioned, and another ground is 6 month separation. Those two grounds, there will be issues that are going to have to be litigated. Now, if one party doesn't want a divorce, they can contest what is irreconcilable differences. What are the factors that you need for a husband and a wife or two spouses to have irreconcilable differences? The statute really doesn't explain specifically what is defined as irreconcilable differences. So those are issues that are going to be litigated. We're going to have to see how the judges come out. Parties are going to file, and one party who doesn't want the divorce is going to say we don't have irreconcilable differences, and people are going to draw out factors and specific facts of why it's irreconcilable, and the other party will say that's not true, and the court's going to have to determine if it qualifies as irreconcilable differences. The other ground that we're going to have is a 6 month separation. What's interesting about that, we do have a 1 year separation ground right now. The 6 month separation ground, though now in the new law, like I said, they're trying to streamline and make divorce a lot easier for people. They are, in the 6 month separation, they're stating, the new law says that you do not have to be physically separate and apart for those 6 months, which is a dramatic change. And that means you can still live together and qualify as separated by stating certain facts. Now, those facts of what the court's going to say, are you separated but still living under the same roof, is going to be determined by the court and the factors. I would state clearly that if both parties allege that they've been living under the same roof, but the wife or the husband stays in the basement and the other party stays upstairs, they probably will say they're separated, and if it's been for the statutory period of 6 months. But other factors that the court may want are that the parties have different bank accounts, they have different expenses, they live separate lives, but they live under the same roof. These are all things that we're going to see as attorneys, and the court system is going to determine what is separate for the last 6 months but living under the same roof. So it's very interesting why this legislature did this. They're basically trying to streamline the process and improve the economic resources that the judicial system has to provide for the grounds for divorce, to get for the parties to get a divorce. Excuse me. Now there are things that we litigate which are dealing with the grounds for divorce, meaning if you want to talk about cruelty or you want to talk about adultery, the law has not changed going forward after October 1st, but those factors will be looked at and parties will bring them up for other reasons, not for the grounds for divorce, but for the purpose of claims that you have under the statute, under the Maryland Divorce Marital Property Statute, which is for monetary award, which is the distribution of marital property, or for the alimony statute that says that you can claim who caused the dissolution of the marriage if you're asking for alimony. These factors of who caused the dissolution will still be there. So you will see those issues, and you will need an attorney to litigate and somebody on your side to advocate for those. So those are the three new elements of divorce. There is, like I said, the public policy is to streamline, but issues are still going to be there, and we don't know how everything will draw out as time goes forward on these issues. Now, there are several other new provisions of the law that I'd like to just bring up with you, and I'm just going to bring them up briefly, but if you do want to discuss them, please contact my law firm regarding the issues that I've already brought up on the law and how it'll apply to you. Call me at my law firm, 301-315-0001. But the three other new laws that I want to bring up with you is, one is that if there is a relocation, for instance, you have a child custody order in place, and one party decides to leave the jurisdiction, currently you have to file a modification, but that party could leave even though you're saying there's a modification of custody because one party's moving out of the area. What the new statute after October 1st allows for is that the court system should provide an expedited hearing if somebody files a claim that somebody's leaving the state and it's going to affect the current order, access and visitation schedule, it's going to affect it, then they can ask for an expedited hearing. Question is, going forward, what is an expedited hearing? Nobody's defined expedited hearing. An expedited hearing in Montgomery County may be 2 months, but in another jurisdiction it may be 7 days. So we have to see what an expedited hearing means, that the court has to provide you an expedited hearing by you filing and pleading and requesting that. That's one issue. So that'll be interesting going forward. The second thing is, a new law is that if you have a child support order where there's arrears that you still have arrears from the other party, the new law allows that child support arrears can be attached, the judgment for the child support arrears can be attached to a workman's compensation insurance plan. So if you have a workman's comp, somebody collecting from workman's comp, you can attach 25% of that the net recovery from the workman's comp benefit that you're getting. You can collect 25% of that from the net recovery of the weekly benefits, or from any of the settlement proceeds from the workman's comp claim. The last thing I'd like to mention today is that Maryland is instituting new laws that prohibit minors under the age of 17 from marrying, and they're establishing specific procedures for obtaining a court's permission for a 17-year-old on how to get married. So basically they're prohibiting anybody under 17 from marrying, and then setting up specific procedures and processes for a 17-year-old to be married if they are looking to get married. Again, these are small things that are occurring, but the landmark statute that has been implemented in Maryland, and that is going to be going in full force in about 6 weeks here, is going to dramatically change the way each law firm that does divorce, how they're going to approach a case, how the court system is going to define all these things that I've brought up today. And if you want any guidance on if you're looking to file a divorce or if you've already filed a court case and it is pending and how it's going to affect after October 1st, please give me a call. And you will have to amend, if you have filed a limited divorce, you will have to amend your complaint after October 1st, because the separation period will be different, and how the courts approach that limited divorce will also be different. So I'll look forward to hearing anybody that needs some guidance or any questions in the future. Thank you.